So just to summarize what you've just told us, please correct me if I go wrong anywhere. You basically meant to say that the land titling prescription, so to say, or the advice that was given by Niti Aayog was not to Andhra Pradesh, and Andhra Pradesh need not have taken it as seriously as it took that particular prescription. It was for other territories of India which did not go through the permanent settlement process in 1851, which did not have a concrete system to resolve disputes. And you also feel that the farmers, to an extent, have been disempowered and have been misled by giving only a chunk of what was made of their land back to them. And this immensely benefited the government or certain agencies, so to say. Going forward, the standpoint that they come from, they say this was with an intention of settling all disputes once and for all. But on one hand, we say we want to settle disputes once and for all. But on the other hand, when you told us about the history, I realized technology may not be the answer for every question that is raised by either the public or raised by the situation, so to say. So where do you feel the gap arose, and where do you feel it all went wrong? And to an extent, was the intention in the first place wrong, I would say?
Okay, let me, I think number one, first and foremost, the Niti Aayog prescription, it was meant for those areas that did not go through the Raitwari settlement, mostly the permanent settlement in way back in the 18th century. Second is 18th, 19th centuries. Second is, it did have a role in states like Telangana, northern India. It didn't have much of a role in Andhra Pradesh. However, there were problems in Andhra. It's not that Andhra Pradesh was free from land litigation. What it required was more efficient, more effective land management system. The rules, the regulations, the procedures were all in place. They just simply needed to be implemented. This whole idea that you have a permanent title is misleading the public.
And I'm sorry to interrupt you here, sir. When somebody says permanent titling, how permanent is it? I mean, for all you know, the next government comes around and says it's not permanent.
Yeah. No, I mean, what normally, I mean, what happens across the world is that the sovereign owns all the land.
Yes.
This is the eminent domain doctrine. Doctrine of eminent domain dictates that all land is vested in the sovereign.
Yes.
The sovereign in India are the people.
Yes.
And the government administers the land on their behalf. That is why the government reserves the right to acquire land in public interest. You cannot stop that right.
Exactly.
That is in terms of exercising the doctrine of eminent domain, that the government acquires the land. So the title of the land that is given as a patta, as whatever is the title, is permanent as for you to, number one, trade in it, unless it's a government assignment or government alienation. You can trade, you can sell, you can buy, and you can give it to whomever you want, your successors or your spouse or whoever. So to that extent, your ownership is protected.
Yes.
So this logic, this argument by the previous government was disingenuous. It had absolutely no basis. It arose from two reasons. One reason, in my view, was poor understanding of land administration, and IAS officers are not expected to have deep insight or deep knowledge of the land administration because they do million things. This is one among that. And I was one of those few who have had the fortune of working deeply, because I worked in some of those areas in Telangana which were not settled and surveyed. So I know I have had the advantage of conducting a survey, settlement, and then
first-hand experience of dealing with land.
I mean, what was meant under the Land Titling Act. The second one was, here the second logic was essentially asking the owner, title holder, to prove his own ownership title. Number two, to show his own land. When you have land maps available, you have the records available. Now, why should, I mean, where is the need you place the onus on the farmer? Third, more important is the domain of the civil courts was excluded. And the revenue courts, already revenue courts are overburdened. Yes. They are poorly managed. Essentially the problems have arisen in the land domain, essentially because of poor land administration. So this entire effort, in my view, was meant to benefit drone flyers, stone planters, and those who digitize this information. I would like to believe, in all good faith, that the intention was essentially to trace how much land Akash holds in Andhra Pradesh or how much land that Ramesh holds, and then go after those who are not liked by the party in power. So I do not believe the intentions were honest. I do not believe the process was fair. And I do believe that it is, and I'm very happy that this government, one of its earliest decisions is to do away with the legislation. And I now believe what this government must do is to go back to where it was 20 years back, before the webland came into existence, restore back the adangals, restore back the record of rights, trace out the record, put it in the public domain.
Exactly.
Let every farmer know where it is. Where subdivisions need to be made, obviously, if the father dies and the children inherit, you need to do a subdivision.
Exactly.
Or if a landowner sells it to two different people, they perhaps would have to be subdivided.
Exactly.
So this exercise, the updatement of the records, is what is required. I think I personally believe both webland in Andhra and the Dharani portal in Telangana have done huge damage to the real owners and farmers of the land. It has enabled land grabbers to grab large chunks of valuable urban properties and expropriate land at a price. And I think this is a huge crime. This must be dealt. Telangana has done away with the Land Grabbing Act, whereas it is still valid in Andhra. The government must do a series of reforms. It must appoint senior people who have experience in land administration, restore back, and then all the land that has been grabbed in the name of assignments, assigned lands, as well as the pata lands. Then there needs to be a comprehensive investigation into this, and the lands must be restored back. Otherwise, it must be taken to the government domain, so that the government could benefit from this. I mean, it could use it to establish industrial parks, industrial special economic zones. Yeah, for the development of the state. Monetize those lands. So I think the time has come. This has been one of the biggest, I mean, this is among the several irregularities and crimes committed by the previous government. This stands at the forefront because of the fact that 60% of the people are dependent on land. And then this was also extended to urban lands.
Exactly.
In fact, urban resurvey has not started. Had it started, it would have created havoc with the ownership of the...
Because the popular belief that most of the power centers sit in the urban areas.